Okay, welcome to your last mini lecture. This is over forensic psychology, and I'm really only going to focus on a couple of key components here, some things that individuals often get wrong. The first thing is something that the book got wrong, and this has to do with confidentiality and the duty or right that a therapist has to protect individuals. So your book actually says that a therapist has a duty to warn an individual. Notice I do not have the word warn up here. That is actually inaccurate. If you look at the case law, it is a duty to protect people. There's a slight difference here. So what we're talking about typically is if a client says, I'm going to kill this person. And they say it and they really mean it. And so we actually think there's homicidal intent. We don't have a duty to call up that person and say, hey, so-and-so is going to harm you. We could do that if we needed to, but what we do have a duty to do is to try to protect that person. We want to protect them from our client. And so usually the way we do that is through what we call involuntary commitment or civil commitment. That means that I call up the police and I say, hey, so-and-so is homicidal, so I need you to go and I need you to arrest this person. And what they do is they take them into custody at a hospital. And there's all sorts of legal proceedings and stuff associated with that I'm not going to get into the details of. But essentially, the way we usually protect an intended victim is not to warn them, but actually to have our client committed so that they're inpatient, they're getting treatment with the idea that they will not be released until that homicidal intent is gone. So that's usually what we want to do. We also have a duty to protect the client. And so this revolves around confidentiality and suicidal ideation. So if a client is suicidal and they say, hey, I'm going to go kill myself, we have a duty to try to protect that person. And so sometimes that does mean that we actually break confidentiality to protect them. There's other reasons why we might break confidentiality, and those are listed within your reading. But otherwise, anything that is said by a client to a therapist, ethically we have to protect, it's called confidentiality, and legally it's called privilege. So unless there are some certain exceptions, I don't actually have to reveal case notes to anybody. So I want to make sure you guys understand that it's duty to protect. We have to protect the public and any intended victims, but we also have a duty to protect our clients in terms of their suicidality. Now, there's two different kinds of commitment. Civil commitment, as I've just discussed, where I commit somebody to a hospital because I'm afraid they're going to do something that will harm other people. And there's criminal commitment, where an individual has committed some kind of crime and they're now being committed for treatment. That's usually associated with this thing called not guilty by reasons of insanity, or the insanity defense. Now this is one that a lot of people get wrong. They think a lot of people plead insanity and then they get off scot-free. Actually, there's very few cases that actually plead insanity because it's very difficult to prove insanity. And then only a small fraction of those cases does the jury or the judge actually say, yes, this is not guilty by reasons of insanity. So it's actually less than 1% of cases in the US end up with a verdict not guilty by reasons of insanity. So it's a really, really small number, but the press often just jumps on these insanity cases. So what does it mean? Well, it means that we don't hold you responsible for your actions. You are not guilty. However, you don't go off scot-free. Because you have some kind of illness or something that caused you to commit the crime, you need to be treated for that. And you're going to be treated for that in a commitment kind of way. What that means is that you usually go into a hospital or inpatient setting and you're not released until you're better. So when you commit a crime and you get a prison sentence, there's a point where that prison sentence ends. When you're committed criminally or civilly sometimes, there's no end point. It's whenever you're better. So keep that in mind. Oftentimes the people who go in because of criminal commitment are committed or actually in an inpatient setting longer than if they were simply found guilty of whatever crime it was. Because the most common crime really is not murder like we think. It's actually like assault or theft or something like that. Often they're committed longer than if they had just been found guilty and served their time. So there's a lot of things that are kind of myths when it comes to this not guilty because of reasons of insanity. It's really not common, and the people really don't get off scot-free. Lots of other cool stuff in this chapter, so make sure you check that out. And if you have any questions, make sure you post them.